Well, thanks everyone for joining us today. My name's Hannah Powell, and it's a pleasure to be with you all. I know most of you, I think, so, and I expect that we'll have some more people log on as we go forward in the meeting. But it's my pleasure to be here today with Patrick Horrell, who is an attorney. There's Patrick. He's going to talk to us about a range of estate planning issues. Before we kind of dive into all of that, I just wanted to offer a couple anecdotes of my own of why I feel this is so important. My mother was actually a paralegal for an estate law firm. And so I was very young when I think I was like 19 or 20 when she insisted that I have all of my estate planning documents. But I kind of grew up on these stories of people who hadn't thought through end of life issues. And consequently, lawyers had to get involved in what are very personal and difficult issues for families to deal with. Lots of families who, when one parent becomes incapacitated, then has to think through a whole host of things, whether it be who's caring for children if they're underage, or how the doctors are going to handle various procedures, and how the family can perhaps not become impoverished but still qualify for Medicaid and other aid that we have to help people in times of crises. So anyway, all of that said, there's a lot to cover, and I'm just really encouraged that there was some interest in folks coming out and participating in this event. But it's not just for elderly folks as well, and that's probably why my mother was so insistent that all of these documents were prepared when I was just 19 or 20. But it's my pleasure to have Patrick here with us. Patrick is an attorney that I first met a couple of years ago because he was appointed by the court. He actually serves as a fiduciary for DC Superior Court. So he gets tasked to come into cases where a trusted attorney needs to come in and speak for someone who is elderly, or it could be even children, if I'm correct, Patrick, but speak on their behalf. So he's actually trusted by the court to serve in this role. He was asked to come and participate in a case that involves actually my next door neighbors who both ended up passing away just a couple years ago. But because they have died intestate, meaning they died without a will, their estate, meaning really just their house that they lived in for a good 50 or 60 years, that is it's a question of what's going to happen to it, and it's been dragging out in the courts for 2 years now, all because they didn't have their wills or their estate planning documents in place. So these things really are important. Unfortunately, when people don't have these documents, the lawyers have to step in, and so we try and do some planning in advance so that it doesn't have to go down that road. But let me just tell you a little bit about Patrick. So I mentioned that he is a fiduciary for the DC Superior Court. He also sits on the estate, trusts, and probate law section of the DC Bar. He's a partner with his firm Farenholz Horrell, and actually has a wide range of legal expertise, not only in the estate planning issues that we're talking about, like guardianships, probate, estate and trust administration, but he also has experience with real estate, civil litigation, etc. So I'm very excited that he could be here today. Just a couple administrative notes. One, if you're new to Zoom, there is something called a speaker view on the top right-hand corner of your screen. That way you'll be able to just focus in on Patrick. So if you haven't done that already, you can just click on the speaker view up at the top right-hand corner. Second, if you have questions, Patrick's going to speak for about 20, maybe 25 minutes or so, and then we're really just going to open it up to questions and try and take as many questions as we can. So if you have questions, you can go ahead and put them into the chat, and the chat is down at the bottom section of your screen. You should see an icon for chat, so you can type questions as Patrick is speaking, and then I will help moderate after he's done with his presentation. And we'll just try and get to as many questions as possible. So with that, Patrick, thanks again for coming, and I'll turn it over to you.
Yeah, thank you very much for that very kind introduction. And everybody can hear me okay, right? Okay, great. Let me first say how impressed I am that all of you are here on a Saturday morning discussing these issues. I think it's great. And I think the more people that take a conscientious approach to setting out what they want in writing, the better. Because as Hannah was saying, in my practice, I often get put into these situations because people haven't been writing anything down. And then the court expects me to make a decision for somebody that I've never met. And they never took the time to write anything down before the time where they had a stroke and they can no longer talk, or they've been put in a medically induced coma. So putting these things down in writing avoids the unexpected outcomes that we would all fear. And the other purpose of this seminar is that legal services is a product like anything else you'd buy. Just like a car or a piece of furniture, the more educated you are about what you're buying, the better experience you'll have, and the more the product will be tailored to what you actually want. So maybe you can use this discussion we're having this morning in the event that you do choose to do some estate planning. When you do talk to an attorney, you'll know some of the lingo and some of the things that you should ask that attorney in the planning that they do for you, because there's a lot of things that can be done, and there's oftentimes a generic approach that is taken which may not fit all people. So if you have some particular circumstance that I identify here this morning, you might want to hang your hat on that whenever you do talk to an attorney. So let me just quickly go through my background. I'm licensed in Virginia, Maryland, DC, and my home state of Missouri, although I rarely practice there. I am based in DC, and the primary part of my practice is with the Superior Court here in town. That being said, I do serve on the fiduciary panel, as Hannah was saying, and I am oftentimes hired by people from around the country to perform fiduciary services. Most recently, I was hired by a guy in Oklahoma who had written some things down that were no longer applicable, and he needed someone of my expertise to help. So I performed services in Oklahoma, but that was on an ad hoc basis. But I do fiduciary services across the country, and I've been doing this since about 2008. So with that being said, there are three primary documents that I'm going to go through this morning. The power of attorney for finances, the healthcare directive, and of course the last will and testament. And the last document, the will, I'm going to put a little asterisk by it because a lot of people end up doing a living trust which somewhat supplants the will. So I'll discuss that when we get there. So first, I'll go into the power of attorney for finances. And in DC, this is the first thing I'm going to mention because it is the biggest pitfall. In DC, there is a code provision that says a power of attorney cannot handle real estate unless there's a very big block of bolded, and it has to be bold. If it's not bold, the title companies won't accept it. A very big block of bolded text at the very top of the power of attorney that has a very specific wording. If that is not included, you cannot handle the real estate. And a lot of people that use LegalZoom or another type of online form provider never get that language. And then 10 years later, when that document becomes relevant, it is a non-issue. And they end up having to go to probate court to get a guardian or conservator appointed to handle the real estate issues. And it is a disaster because costs whenever you go to court are expensive. Now you've got lawyers, and when you have court-appointed lawyers, they get paid out of your assets. That's a disaster. So the more you can write down, the better, because it avoids confusion and it avoids court involvement. So that being said, the power of attorney is a very basic document, and it can be tailored to whatever you would want to empower someone to do from a financial perspective. And a lot of people think, if I have a power of attorney and I put a blurb in there about my healthcare decisions, that's sufficient. That can oftentimes be wrong, and it can oftentimes not be nearly detailed enough. So I tell people to divorce the power of attorney for finances from the healthcare directive. And oftentimes, the person you'd want managing your pocketbook may not be the person you want talking to your doctor. And that is a difficult conversation that a lot of people have with their brother, sister, son, father, mother. The accountant of the family may not be the best person to talk to the doctor. So keep that in mind. You're allowed to choose different fiduciaries for different roles, although most people choose the same one for all roles. People can customize the way they want their estate plan done. And that is the benefit of doing this in advance. So let me just do a lot of people also, when I said the word guardian and conservator, people think, oh, okay, so there's a court option here as well. Let me explain the breakdown. So a power of attorney is when you willingly give someone what is in essence your civil rights, your power of contract, your power to make decisions for you. Those civil rights you lay in the lap of somebody else willingly. A guardian and conservator is when the court reaches out and takes those civil rights and lays them in someone else's lap involuntarily. Of course, you can consent to a guardian and conservator, but in essence, it is a taking action. So guardians and conservators normally come about when someone isn't able to appreciably give those powers away because of a legal incapacity, because of a medical issue, or because and in some circumstances, people can't be found. They're unable to comment at all about what they would want to happen. So it's better to write these things down in advance, lest you have the court come in and make those decisions for you. And someone like me could be appointed who you don't know from Adam or Eve, and I make some very personal decisions on your behalf because you never wrote anything down, or because your son, daughter, father, mother, brother has decided they don't want to make those decisions. They say, hey, I live in Seattle. Why would I be handling matters for a piece of DC real estate? I'm a busy guy. I've got my own family. The court then steps in and gets involved and then appoints a neutral and disinterested member of the bar, such as myself. So the power of attorney for finances, the two big things are the avoiding the guardianship and conservatorship process, which is expensive. And of course, that giant block of text at the top. So if any of you talk to an attorney and they're going to prepare for you a power of attorney for finances, say, hey, will it have the giant block of text at the top? And if it doesn't, they're making a big mistake, and it might be a better idea to talk to a different estate planning attorney, because a lot of people don't do this for a living and don't know that it's out there. So if they don't know that that's an issue, it's probably better to say, hey, maybe I should talk to somebody else. Thanks for your time. So that being said, let me move on to the healthcare directive. And in the age of COVID, this document has received renewed attention, and I think it's a very welcome thing. When you think healthcare directive, don't think the appointment of an agent, which of course it does, but think, what sort of treatment do you want? That's the operative power of the healthcare directive. You can appoint somebody to make your healthcare decisions for you, but if you never tell them what you want, you're putting that person in a terrible position. What if they're faced with the decision about terminal treatment, where they can approve for you something that would be very painful and miserable with a maybe 10% chance of survival, or they can let you die a natural death? That is no choice to leave to somebody without first giving them an idea of what you would have wanted. So the power of a healthcare directive is not necessarily appointing somebody, which of course it is, but it is the power of deciding what types of treatment that you want. And the three big ones are artificial feeding, artificial hydration, and code status. In my experience, and I've been doing this for a long time, and I do this for a lot of people that I've never met, and I've spoken to a lot of other practitioners about this, the feeding tube comes up in a lot more cases than you think it would. And unless, in my position, unless the feeding tube has a restorative goal, if it's merely preservation and it's not restorative, I oftentimes refuse the feeding tube because it does not improve quality of life. There's not a lot of energy you can get from that thing. It is designed to keep you alive, to be able to watch TV. That's about it. So if you don't write that down, some agent of yours may be confronted with a choice where they say, hey, some doctor comes up to them and they say, hey, we're going to install a J tube, which is a jugostomy tube, which goes into the side of your body. And we're just going to install a feeding tube. We'd ask you to consent. It's a pretty standard procedure, blah, 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 blah. And of course, coming from a doctor, your agent is going to say, oh, yeah, that sounds completely normal. However, that doctor is consigning whoever it is that is going to be receiving that tube to what could be a very terrible fate. How do you remove a feeding tube once it's already in? You're then confronting a much more difficult decision, which is withdrawal of care versus withholding care, which I think is a completely different decision. The same principles can be applied to artificial hydration. What would in essence be a natural death can be dragged out for a very long time with what's called a TPN, which is a little line that goes in behind your ear and supplies you with all of the things nature requires you to have, but nothing more. And those things are routinely done by doctors without really thinking about the long-term implications of those decisions. These doctors, they do this all the time, and without having a document out there that your agent confronted with what may be an emotional decision, a very emotional decision, if they can just hand a doctor a document that you signed that says everything that you wanted to happen, no feeding tube, no hydration, no code status, it makes it it takes a lot of the heat off of the appointed fiduciary and allows them to focus more on caring for you versus thinking about all the things you maybe would have wanted based upon conversations you maybe would have had over 20 years. So it's a very, very, very important document. And then the last thing I mentioned was code status. When you hear code status, think chest compressions. Let's say that you're very sick and you have what is probably a terminal condition. You may want to just allow yourself to be let go and die a natural death. However, without writing things down, doctors may begin, in your final moments, begin doing chest compressions on you and extreme interventions, loading you up full of vasopressors to get your blood flowing. And you may not want any of this. And they do it anyway, because either they couldn't get a hold of anybody or they didn't know what you would have wanted. And let me back up and say that the healthcare directive, when your agent gives that to the doctor, that goes in your chart at the very top. So all the things that the nurses and the doctors use when they're treating you, the healthcare directive is at the very top. And whenever they open that chart to figure out what's going on with you, they see that you've already written all this stuff down. And they're going to look at that before they decide, can we do chest compressions? Oh, let me look in the chart. And then they look in the chart, they see that there's a directive, and it says no chest compressions, no code. And they don't do anything, and you pass in a natural way without a lot of unnecessary, what may be unnecessary medical intervention. And now for sort of to bookend this little discussion of what I'll call the living documents, the power of attorney and the healthcare directive, everybody thinks, okay, so I've got these two documents out there. I'm appointing my wife or husband I'm good to go. That doesn't take into account that you two may be in the same car, or whatever the mode of disaster is, you may be together. So people need to think about who they would appoint as successor. And the successor discussion is where a lot of my practice is involved. Because for whatever reason, the appointed fiduciary, by virtue of a divorce or a separation or some other type of, or a death, a successor is put into a situation that they never planned for. They say, I didn't even know I was in this document, and now I'm making a decision for my friend Bob. What do? I live in Montana. I get involved in a lot of these circumstances. So put a lot of thought into who you would choose as not the primary agent, which may be very obvious to you, but the successor agent, because that backstop person could end up in the driver's seat, and it warrants a discussion with them. So you may appoint somebody without ever having talked to them about it, thinking that the set of circumstances necessary for them to step into the shoes of you in Washington, D.C. in your life is so remote that it doesn't even warrant talking with them. Absolutely not. Talk to that person. If you're going to put them in a document, say, hey, Bob, I'm going to appoint you as my successor agent in these two documents. Should it come up, should something happen to me or my wife, you're going to be in the driver's seat. And then that way the person at least knows that they're out there. And I would also suggest that if you do any estate planning, put this person's phone number in these documents. A lot of these documents only have addresses, and that does not allow for an immediate communication in very tense circumstances. So make sure that a phone number, better yet an email address, is always included in all of this stuff. Because in an expedient circumstance where a decision needs to be made emergently, you're going to want immediate communication. So with that said, I will move on to the final document, which is the last will and testament. The will, everybody knows what a will is, and I don't need to go into a lot of detail, but I will discuss two very important points. The first is the memorial. Not a lot of people in their will set out what they would want their memorial to look like or what their disposition looks like, i.e. cremation or burial or any other type of disposition that you may choose. Some people set that out in the healthcare directive to make it easier for the hospital whenever the hospital is making those types of decisions after death. I put it in both just to make sure that there is no conflict between the two. And I would suggest that any planning attorney that you talk to, put it in both. It only helps. It does not hurt to have echoing documents because it makes it easier for all parties to understand what's going on and what you would have wanted. So the memorial, I always put a section in the will about the memorial and disposition. And without setting these things out, whoever is making these decisions for you after death, and it may not be the person you think it is because your original chosen agent has predeceased or is no longer in your life. The successor may be making a very intimate choice for you. They may be choosing things concerning your burial, and they may be choosing things concerning the manner of disposition itself, such as cremation. That is no decision to leave to somebody without having discussed it with them first, or better yet, written it down. Make their lives easy, write it down, put it in the will, put it in the healthcare directive. The other thing I'll mention about the will can waive bond. If you are to pass without a will, you have to probate the estate. And probate is the concept of, it's the name of the court building where all of these issues are brought to the fore. The bond issue comes up when someone dies without a will that did not waive bond. So if you die without a will, you die intestate, and whoever your agent is needs to go out and procure a bond to allow them to serve. And you can only get a bond if your credit rating is above 650. So if you have somebody that you want to handle your affairs and you die without a will, they will have to go get a bond. And if they can't qualify for a bond, there may be problems depending on what your estate looks like. So the will removes that bond consideration, which can be expensive. You can waive it, and the court respects that, and it does away with the bond, and whoever your fiduciary is going to be able to serve without posting any of that nasty stuff. The will is a very old, basic document. And the only way a will has any force and effect is if it is approved by a judge and that judge establishes a case for it and causes the clerk to issue what are called letters of administration. So when you think will, think I have to go to court. The only way a will has any force and effect is if a judge baptizes it first. So just because you have a will doesn't mean that somebody is going to be able to go out there and do a bunch of stuff for you first. They got to go to court. If you want to avoid court, this is where that asterisk that I mentioned at the very beginning of our talk comes into play. You want to avoid court, you can do what's called a revocable living trust. And the cost for a revocable living trust is more because it's a document that you can use today. It's much longer. It has some tax consequences. It involves a conversation with your accountant in all likelihood. But it allows for the retitling of assets during your lifetime to avoid probate. So if you have a trust, you can be the trustee during your lifetime. Of the Patrick Horrell Living Trust, which I do have, I'm my own trustee. So I manage my own affairs. I manage my own life. If I were to go out and get hit by a bus, I have a successor trustee that would never need to go to court to get any authority to act on my behalf. Because the minute that they have a death certificate for me, they are now the successor trustee. And day 2 after the event, they can go in and start taking action. Whereas if you have to go through probate, the probate court can take up to 6 months before anybody has any authority to do anything for you. 6 months, possibly. It can be shorter, it can be longer. Trustee, 2 days, sometimes shorter, depending on how quickly they can get a death certificate. So it's very important if you have assets that need to be actively managed, such as, and I always use this example, rental property or basement tenant. If you have rental property, it may be a good idea to do a trust, because after you die, your tenant can legitimately say, I'm not paying anyone anything until they show me some legal authority. And they're right. And guess what? They're living rent-free for 6 months. That's bad. If you have a trustee, day 2, they can come in and say, hey, pay me rent. I'm trustee. And that's all they need to do. So it's an important document. If you have a business affairs that need active management, a trust may be the best option because it avoids probate, avoids the judge, and it allows for retitling of assets during your lifetime. And one final point I'll mention in that regard, 401ks, bank accounts, liquid assets of that nature. A lot of banks, 99% of 401ks and Roths and whatever else you're gonna look at, allow you to designate beneficiaries. Do it. It avoids probate. And just like the trust, once a death certificate is presented, your designated beneficiaries can come forward and claim those assets in an immediate way. Those assets never fall under your will. They don't fall into probate. They pass what's called outside of probate. They are non-probate transfers. And it is much easier, cleaner, and less emotional for all involved to designate beneficiaries and allow that stuff to pass outside of probate. So to the extent that you can do that now, a lot of people don't fill out those forms. Clients come into my office, they hand me a stack of stuff that they got out of somebody's desk, and I look at I flip to the designated beneficiary page, and it's blank, and I think, we have probate assets, that's terrible. Now all of this stuff has to go into the estate. It's going to be a nightmare. I'm going to have to get the legal arm of whatever this investment house is, and they're going to have to do their own legal review, and it's going to take months. What would have taken days now takes months. And at a time when somebody may not have the money to pay for burial services, this is a disaster. So designate those beneficiaries. Let people know that they're the designated beneficiaries unless you want to really surprise them. It's a great way to do things because it avoids probate and it avoids excess cost and also avoids time. And a lot of these circumstances, as you know from our little talk here, the cost is often time. So the extent that you can save people time, you can do that through planning, through a trust. With that, I will conclude my little spiel. And if you guys got any questions, I'm happy to answer.
Thanks, Patrick. I have a joke that, you know, a good attorney is someone who scares the pants off of you. And I think you've done that very well today. Appreciate that. So just a reminder, everyone, you can put questions into the chat, and I'm just going to help moderate here with Patrick. And Patrick, I'll just kick off with a couple quick questions. So you've talked about the three main documents that you think it sounds like everyone needs: a power of attorney, the healthcare directive, and a last will and testament. Mm-hmm. Are there anything special? Is there anything special with? Sorry, my cat. There's background noise. My cats are apparently tearing something up right now. But is there anything special with, say, parents who have minor children? Are there separate documents that they need to be thinking about? Obviously, if both parents are in a car accident, what happens to the kids would be a really important question. Does that have to be codified somehow in a document?
So the word that I'll latch onto there is codified. There is, in the family law context, there are statutes that set out a hierarchy of people that come into play without ever having written anything down, who is going to be making decisions on behalf of a minor child. That being said, if you have a particular person in mind, because that hierarchy may say brother or sister of deceased, that may be, you know, that's a person that's very high on that list. If you have 5 brothers and sisters and 2 of them believe they have equal rights to those children, guess what? You now have a fight on your hands. And that's not a pleasant fight to have when you're dealing with the death of 2 loved ones already. Or 1 loved one, however it shakes out. So it's no position to put someone in your estate planning documents. You could absolutely nominate a guardian, and that's the proper term, or custodian if you're in Maryland. You can absolutely nominate someone to take on that role for your kids in those documents. And that's something that I do as a matter of course for individuals that have children. I say, in the odd event that you guys are in the same car, and you know what they'll say is, wife will have 5 brothers and sisters, husband has 1. Why make it a dispute between 2 sides of the family that are already grieving? Nominate somebody, let them know, and that way it's everybody knows. And should something happen, it's already in their minds. It's already something that's well settled. The kids are going to Nancy's house. That's the way it's working out. And then that is baptized in a court decision later when those documents are approved by the family court. So it makes it an easy decision.
Great, thanks. If there is a surviving spouse, would an investment account still need to be probated?
It depends. So the investment account, they don't know what your circumstances look like. Unless the surviving spouse is somehow already on there or is a designated beneficiary therein, the investment account has no idea what's going on, especially if they've only been dealing with you. So the surviving spouse is still going to have to go through probate and get letters of administration issued to say, hey, I'm the sole heir by virtue of the intestate laws in DC, because nobody ever did a will. Because the intestate laws in DC, the surviving spouse gets everything because there were no children. So therefore, I'm entitled to all these investment assets. You still have to go through that process. the 401k, unless that person is designated or is somehow jointly on the account, is not automatically going to get that asset.
Okay. Do you have any stories of, say, single persons that have perhaps not had these documents in place and what has happened? Because I think sometimes people think that these documents are for once people have property or children, but I know that's not the case. Do you have any stories about why it's important for single people to have these documents as well?
This is an excellent question, and maybe the most important one that's been raised. And single person, the status of single person can arrive in your life without anybody ever considering it. You may consider yourself to not be a single person currently, but 20 years from now, you might be. So it warrants some serious thought. And all of some of the saddest cases that I have are when a person, DC attracts people from all over the country, all over the world. They come here and they live out their lives and they work professionally and they get old here and they lose contact with family and they lose contact with friends. And then they fall down the stairs or they fail to maintain their property and Adult Protective Services gets involved. And someone enters their home and they find no documents. And then the court gets involved and then I get appointed. And then that person who may have had a full life of family, friends through most of their life, through no fault of their own, is now very alone. And I am making decisions for them on a daily basis for the rest of their lives. If you have a trusted attorney or a trusted attorney, if you're a single person, you want to think, who's going to outlive me? Maybe it's a niece, maybe it's a nephew, maybe it's a younger friend, maybe it's a friend's son or daughter. And the more attenuated these people are from you, the more it's important to have a conversation, obviously, because you want to let these persons know that you're thinking of them for a very tough job, a thankless job, so to speak. It's very important to write this stuff down. And this goes back to the successor conversation that I had earlier. You may, when you find yourself single late in life, that successor becomes very important. So single is a status that's very fluid and comes and goes in your life by surprise, oftentimes. So a lot of my saddest cases are when people that I can tell had I go into their homes because now I'm their appointed fiduciary. I go into their homes and I look at all the pictures on the wall and I think this person had what is an incredible life, but now they're utterly alone and I'm it. And it's a very difficult thing. And had they written it down, I may have some guidance as to where to find a friend or somebody that would have known them or would have had some input about whether or not they wanted a feeding tube or whether or not they wanted me to aggressively treat their cancer or whatever it is, but they didn't. So then I'm making a decision. So single people, think about who those agents are, because that's the important question for you. Who's going to be around when you're 85 years old, able to make cogent decisions? Who's a pretty stable person? And to the extent that you may not know anybody, think about an entity such as a law firm or that's usually the way people go. Think of an entity that you could appoint that's going to be around 30 years from now, that if they get a call in the middle of the night, they're going to answer and they're going to be able to act for you on a moment's notice. So that's what I would say regarding the single folks.
Thanks. Can you give us an idea of how much these documents cost? So I think we've kind of talked just about the three basic documents: power of attorney, healthcare directive, last will and testament. Obviously, it can get more complicated after that if you start adding in trusts and everything else. But about how much should people be budgeting for this sort of investment?
So, that's a difficult question because it's very circumstance specific. If you're a single person, you've got a 401k in a house, and it's not super complicated, and you've got basically all your ducks in a row and you've designated your beneficiaries, these documents are very, very easy to prepare. I would still go the route of an attorney because they know the nuances of the law, such as that paragraph that I mentioned, very important. They know the nuances of the law in DC and your local jurisdictions, so they're gonna know what the pitfalls are, and also they're around to verify that the documents are legitimate later on, in case there's ever a question about that. Legitimacy is oftentimes a question that is resolved by the courts. You can avoid that by having an attorney involved because they serve as a witness later as to what you were doing. The cost, For all of these combined, I would say $1,000 to $1,500 is typically what people spend. You can do it for less if your circumstances are very simple. Basically, you're looking at, if an attorney is charging $250 an hour, which is what a lot of my cohorts charge in the probate realm. It's gonna take them an hour to type up a power of attorney. It's going to take them an hour to type up a healthcare directive, and it's going to take an hour to type up a will. You're looking at 3 hours, $750. And then you got to think, I got to do an execution where somebody comes in before a notary public and signs all this stuff. And you're going to talk about it and discuss things. That's probably 30 minutes of discussion and 30 minutes of execution. So that's another hour, which is why I say 1,000. So depending on complexity, it can go more or it can be less. So that's the sliding scale that I use.
Oh, thanks. And if people do want to go down the route of looking at a trust, do you have a rough idea of a simple trust, how many hours that would take?
Simple trust, because of the complexity and tax consequences and retitling, which means taking your trust down to the recorder of deeds in DC, taking your trust over to the bank. Banks sometimes don't know what to do with this, even though they deal with it every day. They look at every single trust and it comes in the door and they think, oh boy, what do I do with this? It's a constant problem that we have because all these banks have their own legal departments. And they all are not here. They're all in Texas or South Dakota or wherever. So trusts, I say 3 hours of drafting and then probably another 2 to 3 hours of negotiations with whomever is trying to take it. So that's why I say for a trust, it's more expensive. Probably, where a will would cost you, $750 with your basic estate planning package, a trust is going to run you another $1,000 before all is said and done, just to get the thing up and running and to the point where it has operative status, meaning a trust is no good if it sits in your drawer. You can't retitle assets after you die. So if your trust never is used to retitle things during your lifetime, it's useless. I recently discovered a trust that was never used to retitle anything. It was just sitting in a drawer. Total waste. The trustee could have saved a year plus of litigation and nonsense by just doing what the person would have wanted. But that trust sat in a drawer and it was never used for anything. So it can be very frustrating. So trust, remember, it's not just a document that you get and put into a drawer. No, it is a document you go out and you use immediately, and then you can put it in the drawer.
Okay. We have a couple questions about power of attorneys. One, someone lives in Maryland and has a Maryland will, a Maryland power of attorney, et cetera, but owns a condo in DC. Does that bolded language that you spoke about need to be added to the Maryland power of attorney, or does there need to be a separate power of attorney for DC?
Separate power of attorney. That's no title company is going to. So if you take a Maryland power of attorney into DC to deal with DC real estate, a title company is going to look at you like you're from Mars. They're going to say, no. You gotta. They're going to say, hey, you need to go to court and get some kind of authority for handling this property, because the language isn't on there. It's the language is of warning nature. So it just simply warns the person who's signing the power of attorney that it could be used for real estate purposes. And without that warning language, nobody's going to accept it in DC.
So, and does the power of attorney for a person's finances give the power to that agent immediately, or only when that person becomes incapacitated?
If you've ever heard of a durable power of attorney, that is a document. So you can do it either way. You can give somebody immediate powers, but you don't let them know that they have immediate powers, and you shove it in a drawer. And that way, if they were to find that document and be nefarious nature, they could go out and do all sorts of nonsense. But for a trusted individual, you could name your spouse or your children immediate agents and shove that in a drawer, and their power to act day one, which is the way I do it sometimes. Or you can make it upon certification of incapacity. That's the other way, where it's a springing power of attorney. So if you're in a hospital and you need someone to collect rent from your basement tenant, your agent would need to go get a certification from the doctor, which they do all the time. They all know exactly what you'd be talking about. They do a certification that you're incapacitated, and then that document gets stuck on the back of the power of attorney, and that gets circulated.
Okay. So the next question is, would you title your car in your name or in the name of the trust?
It depends. If you want to avoid probate, you would title it in the name of the trust. Anything that has the ability to be registered, such as real estate or automobiles or property, can be titled in the name of the trust. So if you want to avoid probate and allow the trustee to go grab the car and have the right and title to use it, absolutely put it in the trust.
Also for the trust, is it true you can have some accounts funded upon your death? Like you could have a non-retirement investment account list the trust as a beneficiary?
Yes. And there's also a way you can create a trust in your will. That's called a pour-over trust, or a testamentary trust if the trust terms are actually set forth in the will. That is one way to do it. That trust springs up. Let's say that you have minor children and you've got a chunk of change and you don't want minor children getting a hold of a chunk of change at 18 years old, right? So let's say that you've got a lot of money and without some statement out there, they get access to your assets once the guardianship and conservatorship for them expires, or the guardianship, depending on what jurisdiction you're in. So you can do a trust in the terms of your will, and that's a testamentary trust. I see a lot of these. I don't do a lot of them because I do trust in advance. I try to do the trust as a separate document done during a lifetime, but a lot of people, some attorneys do the testamentary trust where you can stagger according to age. You can have stepping stones for your children where at 25 years old, they get a third of the assets that you left them. At 30 years old, they get the next third. And at 35, they get the final third. That's oftentimes the way that's amongst attorneys, that's the way it's usually staggered. That 35 is the final boundary for testamentary trusts. But you can do it any way you like. But it's not always a good idea for an 18-year-old kid to receive $3 million. It could be very bad for them. It could interfere with their education. It could do all sorts of nastiness in their life if they're not ready to handle that responsibility. So testamentary trusts is one way to do that.
Are there any pitfalls? You talked a little bit about the durable power of attorney, and so you have kind of two ways of doing it. One, you put it in the drawer so that people don't know that they have these powers. Could you talk a little bit about a power of attorney and kind of what are the powers that you're handing over with the durable power of attorney? I say that because, just as an anecdote, my mother has a durable power of attorney for me, and I have a durable power of attorney for her. So I joke that we're sort of mutually assured destruction. She could clean me out tomorrow, and I could do the same thing the next day. What are some of those pitfalls to be thinking about when you're choosing an agent for under the power of attorney?
So, trust is obviously the first and foremost consideration whenever you're thinking about this. But to the extent that there may not be, for the folks out there that whose network you're naturally cautious of your own network, and maybe that's because of history with them, or family is very complicated. Family is extremely complicated. So you may have a brother that you love dearly, but you wouldn't necessarily want them handling things in a certain way. You may want to limit the powers that they have. A power of attorney, because you're writing this down in advance, you can prescribe in the document whatever circumstances you want. You can remove powers. You can say, oh, they don't have the power to handle my real estate. If they want that kind of power, they're going to have to go to court. But they have the power to go into my bank account, pay my bills, and pay my property taxes or whatever. All of this is eminently customizable. So powers of attorney, because you're doing this in advance, you can customize. So you can really pick and choose what sort of powers you want somebody to have.
So we have actually several folks who might live in one jurisdiction but have property in another jurisdiction. Do you have to do two sets of all of your documents, or can you do one set that somehow will encompass both of the statutory responsibilities in each state?
So I say a qualified once is usually fine. But as with the Maryland question we had earlier about a condo in DC, there's an asterisk there. If you have real estate and you want somebody to be able to sell it in DC, you've got to have that language at the top. There are pitfalls like that in every jurisdiction. So if you tell the estate planning attorney, at the time of, like, hey, this is the big one, Florida, the magnet. Florida is a nightmare for this because they have very particular laws regarding this stuff. And this is not for your protection. This is protection for the practicing bar in Florida to give them business. So Florida has its own regime when it comes to property in the state. And it changes all the time. So Florida does this to generate business for its own practicing bar. So if you have stuff in Florida, or you're planning on going to Florida, definitely talk to an attorney down there. I will not even begin to advise you on what to do if you've got stuff going on in Florida. Talk to a Florida attorney. You can have two attorneys. And you can have one, you can do some estate planning and have it all done and ready to go. But when you do go to Florida, absolutely find an attorney down there and say, hey, can you look over my stuff? I had recently had some folks move here from Arizona. They did all of their estate planning documents there. They got here, they have a minor child, and they just wanted some assurance. They travel pretty frequently, and they wanted some assurance that in the event that they're on the same plane or they're in the same car in whatever country that they do their work, that their probate documents and their planning documents would be just as good here as they were in Arizona. And I looked them over and made sure they satisfied all the statutory requirements of DC, which is where they now live. And I was able to assure them that everything was going to be fine, that their Arizona documents were fine. And that's a service you should do if you end up relocating anyway. You should find a local attorney that is in the jurisdiction that you're in and have them look things over. And once should be enough, unless you've got some particular circumstance that runs afoul of a local law.
Now, what about with the healthcare directive? Is that a document that is really portable? Or if I get sick in another state, is my healthcare directive the doctor's going to be able to use it?
Extremely portable. And the laws concerning these documents have that in mind. And in fact, I represent Children's Hospital here in DC, and I have since the start of my legal career. I represent them in their cases where they may have, because of a car accident or some other nightmarish situation, they have 3 different people that are all trying to make healthcare decisions for a child. They come to me to represent the hospital's interests in what may be a very contentious emergency family proceeding. So then I represent Children's Hospital in those cases. And I could not believe to tell you guys some of the most horrific circumstances one can possibly imagine. And in those types of cases, in emergent cases generally, is the hospital looking in a rigid way at your healthcare directive? Is it looking at it from a legalistic point of view? Absolutely not. Is the hospital's legal department looking at this document? No way. They're looking at it, they're seeing that it's signed by somebody and that it's clearly written and it sets forth some clear directives. Doctors are not lawyers. They're interpreting these things all the time, which is why I say, and it's a qualified statement, that as long as it looks the way it's supposed to look, it's going to be fine. And they're designed, the laws around these documents are designed so that they're very portable, so that one document in one jurisdiction, when you move or you're traveling or whatever and you get hurt, that by some bizarre legal formality prevents your so-and-so from avoiding a feeding tube. No way. And I think to the extent that there's a lot of life that is extra legal, this would always be a subject of a negotiation between you and a doctor that would never enter the realm of a legal department at a hospital. It would be the doctor saying, okay, I get it. Like, we'll do it.
Okay, good. So I think this will actually be our last question. And I just wanted to kind of get your thoughts on how do we approach having these conversations with loved ones? So it might be that we want, perhaps we have all of our documents in place, but our parents are getting older, or we have other loved ones that need to be thinking about these things and maybe don't have these documents in place. Do you have any recommendations on how to approach and have these end of life conversations with those that we care about?
Yes, and what I tell my clients is pick your crisis. Right now we have COVID, and all you have to say is, in the age of COVID, I am thinking about my own mortality and like my family and then all the other circumstances that I'm involved in, my business, whatever. I'm doing a little planning, and I just want to quickly talk to you about some things that I may empower you to do as a successor or a primary agent. Is that something you're comfortable with? Is that something that you'd be willing to do? Is that, and some people hire me and they say, hey, would you mind calling because they don't necessarily understand a lot of this, they understand the decisions that they're making, but they don't understand the operative force of the documents, or they don't want to deal with it. And they say, hey, will you call my brother? And this is something you can put in your attorney. Of course, you pay for the conversation then, but you can have somebody else do it for you. I've called people's family members and I said, hey, Bob may have talked to you about this before, but now I'm going to talk to you about it again. I'm helping you do some estate planning in the age of COVID, and we're discussing doing these things. Is this something you're comfortable with? And then I offer to get Bob on a three-way call if that's necessary, or if they want to talk about it with them, or I say reach out directly. So there are a lot of different ways to do this, but I always say tie it to a crisis. That way, if you fear coming out of the blue, talking to somebody about these issues is somewhat daunting, tie it to the crisis at hand. And our society has provided us with innumerable crises this year, so there's plenty of things to hang your hat on in that regard. And I think that's always the best way to start these, what can be very difficult conversations. It adds some levity, and I think it just lets them know that you're thinking of their best interest at heart as well, because you could appoint them without ever telling them. And then you can also put a joke in there about that. You could say, oh, I thought about just putting you in there, but instead I'm going to talk to you about it and let you know. And that way I'm giving you a chance to say no now versus saying no later, which could be a lot more difficult.
Thanks. So just to wrap up, Patrick is obviously, as been mentioned, he's licensed in DC, Maryland, and Virginia, and he handles a lot of these issues. So he is definitely a resource for you all to reach out to. Patrick, can you share your contact information in case folks do want to reach out and talk to you more about setting up these documents and what the next steps are?
Of course. I have a website. So if you Google me, you're going to find my website. And that's all of my contact information is there. But my email address is P as in Paul, C as in cat, H as in Henry, at F as in Frank, H as in Henry, and then the word firm.com. So PCH at FHfirm.com. And my telephone number is 202-387-8680. And then it's got a dial tree for my extension, and you can just punch it in. And you may not want to hire me, you may just want a recommendation for somebody. I know people all over the place because I do this. So if you're thinking about moving to Florida, ding, 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 the worst state in the union from a estate planning perspective. If you're planning on doing anything in Florida, I can recommend you people in Lee County, in Miami-Dade, all of Broward County. I can recommend people in each and every place in Florida that you may be experiencing some nightmare situation. So let me know. I'm happy to provide recommendations as well. And I know a lot of folks.
Thank you so much, Patrick, for joining us today. And thanks everyone for coming out. Really appreciate it. We just thank you for your time. And hopefully you'll hear from some folks who are interested in setting up these documents. So appreciate it.
Yeah. Thank you all for your attention this morning.
Thanks, guys. Have a good day.
Thank you.
Have a good day.